Okay, welcome everyone to Probate and Guardianship. Before I begin the program, what else can you expect from an attorney but a little bit of a disclaimer? This presentation is for informational and educational purposes only. Nothing in this program is or should be considered legal advice. If you do need legal advice, you should see an attorney in his or her office. Now, we're going to be going over a number of things today in probate and guardianship. Technically, guardianship does occur in the probate court. So we're going to be speaking about three main categories today and what's entailed. The first one is decedent's estate. Basically, that's what most people think of when they think of probate. Somebody has passed away, and how does somebody essentially get to the assets? How are the assets going to be distributed, etc.? There's guardianship for disabled adults who can make decisions for adults who are disabled and have not properly planned ahead, and also guardianship for minor children. Now, the first thing we'll talk about is probate for decedent's estates. So what really is probate? Well, probate is essentially a court process for distributing a deceased person's estate. If you die and you have any real estate in your own name, or if you have $100,000 or more in total without listed beneficiaries who survive you, probate's going to be required. Now, probate's not the end of the world. A lot of times people have said, well, I want to avoid probate because I've been told that if you go through probate, the state takes all of your money. No, that's not the case, although sometimes it does feel like that. But really, probate is there. So when somebody dies, if they haven't properly planned ahead, there's a court process in place to ensure that the appropriate creditors are paid and that the beneficiaries of the estate or the heirs of the estate, receive the money. Now, most probate estate for decedent's estates could be avoided if most people, A, chose to use a good lawyer who did estate planning, and B, if they also listened to their attorney. The only cases for probate that you really cannot avoid for decedent's estate would be A, when somebody has died and the reason for their death is a wrongful death suit, or there was a personal injury or other type of lawsuit that somebody wants to continue. In order to continue any lawsuit or have a wrongful death lawsuit, generally you're going to need to open up a probate estate because you're suing on behalf of somebody who is now deceased. The rest of most other probate cases could usually be easily avoided by proper planning and updating plans as well. So we're going to talk about opening a decedent's estate. This is not how to do probate on your own. This is just what is entailed when there's a probate estate being opened and the things that need to be considered. So the first thing is, when the person died, was there a will or no will? Just because you have a will does not necessarily mean probate is avoided. I'm not going to go a lot into that. I'll go into that next time, or next week when I speak about wills and trusts. But you either have a will or you don't have a will if you're going into probate estate. Also, you need to see what expenses there may be. Oftentimes, it's going to be a lot more expensive to go through probate than it would be if you chose to avoid it. In order to go through probate, you need to have a petition. The petition is basically somebody asking the court to A, admit the will if there is a will, and B, whether there's a will or not, to appoint either the executor, or if there's no will, they're called the administrator, basically who's going to be in charge of the estate. The petition generally has to list who the heirs are, who are the next of kin of the person who died, according to the Illinois Probate Act. And the petition also lists what the person who died, what the decedent's assets were. So is it a house or is it something else or each? So if you died and your house is worth $350,000, it's going to say real estate $350,000 and $800,000 in personal property. That could be bank accounts, cars, whatever it might be. There also has to be notice given, whether there's a will or not. All of your heirs have to be notified. A lot of times people will say, well, I never really I don't have any heirs. Well, you have heirs somewhere, even if you've never heard of them. If it's someone who's, your uncle's cousin twice removed on your mother's side who you've never met, who's in a different country, you do have an heir. They still have to be notified. And despite whether you have a will or not, they do have the right to make a claim on the estate. Of course, if there is no will, most likely they're going to be the beneficiary of their estate. Also, after notice is given, so once the rightful heirs, or if there's a will, the beneficiaries under the will are technically called a legatee, they're all entitled to get notice. Usually they have to send something back, either a waiver of notice. They have to say, okay, we're fine with whoever, is the executor, whoever is being appointed as the administrator, or they can get notice later on and they can state if they're fine with the will and fine with, if there is a will, and fine with the executor or administrator, or they do have the right to submit a claim and say, no, they want the will renounced. Basically, they want it thrown out. And do they or do they not want this executor or administrator? So there's also independent versus supervised administration. Well, what does this mean? And I'll give some examples. I'm not going to try to make this ultra dry. I'm just trying to get through the basic steps. But there's independent versus supervised administration. So most estates are usually independent. That means the executor doesn't have to report to the court for every single thing. Usually the beneficiaries of the estate are trusting that person to accomplish the goals that they're legally required to fulfill. But if somebody is a little weary of the executor or administrator, they don't trust them, they think they're going to steal the money, they can request that the court has supervised administration, where the court is going to basically be watching over the executor or administrator's shoulder. This does cause it to be oftentimes quite a bit more expensive, because it is a little bit more burdensome as far as accountings and getting court approval to do everything, where usually in a general probate estate, for example, if it's independent administration and the executor or administrator wants to sell the house, it's usually pretty simple. If it's supervised administration, they may need to go to the court and get approval to make sure that the amount that's being sold for is correct and all the beneficiaries are fine with that. It's not to say that it's fair or unfair, but if people are in disagreement, it can be very difficult to, for example, sell a piece of house. There's also something called surety, and nobody knows usually what this is except for an estate planning attorney. If somebody dies and they don't have a will, or they have a poorly drafted will, the court is going to require the executor to post something called a surety bond. Basically, it's an insurance policy to ensure that if the executor doesn't pay the creditors or distribute the money to the rightful beneficiaries, that bond is basically an insurance policy to pay them. However, even if there's only one beneficiary and that person is the executor and there wind up being absolutely no creditors, the surety bond is non-refundable. The surety bond, how much that's going to be, depends on the amount of assets and what type of assets they are. So, for example, if it's real estate, the bond is going to be much lower than if it's something like cash or bonds or stocks, etc. However, if the house is sold and now there's money in the estate, they may need to get an additional bond. Most well-drafted wills will waive the surety bond, but if you don't have a will, or if it's a poorly drafted will, surety may be required. There's also heirship, as I pointed out before. Depends who your heirs may be. It may or may not be who you think it is. It's according to the Illinois Probate Act. So I usually tell people, well, if you're married and you have no kids, your sole heir is your spouse. If you're not married and you have children, the heir is your children. But if you're married and you do have children, it's basically $20,000 off the top, and then 50% to the spouse, and then 50% to the children. If you die and you only have parents and no siblings, it all goes to your parents. But if you die and you have parents and siblings, half go to the parents and half go to the siblings. So a lot of things occur that people may not be aware of or may not consider. Unfortunately, by the time they consider it or learn this, it's usually too late to do anything. So After all of this information is provided to the court generally either appoints the executor if there's a will, or it's called the administrator if there's no will, and they issue something called letters of office or letters of administration. When somebody dies, what happens is usually the reason somebody goes to probate is somebody's trying to get the deceased individual's money or sell a house or do something of that nature. And usually the first thing the bank will ask for, or a title company may ask for when somebody is deceased and they're trying to sell the real estate, is a letter of office. And how do you get that? Well, you have to go through all these steps. You have to go through probate. You have to get a petition. You have to give notice. You also have to publish in the newspaper for a number of weeks so any unknown creditors realize this person is deceased and can make a claim, etc. And once the court is satisfied, they'll issue a letter of office, and that gives the executor or administrator the authority to speak to financial institutions, to sell real estate, to open an account in the name of the estate, to get a tax ID number for the estate, which is kind of like the Social Security number for the probate estate. Now, probate, a lot of the reasons people want to avoid probate is the time. Probate takes a minimum of 6 months, not from the time when the person died, but 6 months from the time the probate estate is opened until it can be closed. I really urge anyone, if you need a probate estate opened, especially if you're in Cook County, you should do it as soon as possible. Since COVID, it takes about 3 months to even get a court date. So the earliest you can close an estate is probably about 9 months, although most probate estates, I'd say, are open about a year to a year and a half. Oftentimes it takes a little bit of time to find the assets. It may take a while to sell any real estate, etc. Some estates are more simple, but most of them do take longer than 6 months. And as I stated, a lot of probate estates could be avoided. A lot of times people don't understand, but if you have not properly planned ahead, and keep in mind, as I said earlier, a lot of probate estates could easily be avoided by properly planning. In my program that's going to be next week, also on Wednesday at 7 p.m. at the Eisenhower Library via Zoom, it'll be on wills and trust and how to avoid all of the issues that go into probate. But, you know, I guess I could give a few good examples. I mean, I've had clients who have passed away, and oftentimes it does take a while if they're disorganized to look through their assets, to clean out the house, to get court approval, to perhaps, you know, sometimes find all the heirs of the estate, to send them notice, to get some kind of, you know, response from the heirs. Because, for example, at the moment, I've got one estate open and there was a will, but there are 13 or 14 beneficiaries. It's not that people didn't agree, but in order for me to get the estate open, I had to wait for 13, you know, well, it was between individuals and charities, but I had to wait for these organizations and people to get their waivers of notice back before I could open the estate. And lo and behold, the one place that was keeping the estate from being opened, they were the beneficiary. It was a charity that was receiving the most money. They were receiving more than everyone else combined. Just the person there took a while. If you see next time when we talk about trust, you know, this could all be alleviated. The estate could be opened and distributed much more quickly. So as I stated before, you know, if you go to probate, it's really not the end of the world. It'll take longer, it'll be more expensive, but everything can be completed. It's just there is a more efficient and time-effective way to do so. However, you know, if somebody is already deceased or if somebody is disabled and you can't do a will or trust for them or add beneficiaries, this may be your only avenue, and you should do so and do so correctly. Unlike a lot of the other courtrooms, the probate court is much more conservative. They usually don't like attorneys who are not familiar with probate. And, you know, they have their hands full, especially since COVID with a ton of cases in Cook County, especially, but even the collar counties like Lake and DuPage, et cetera, which I also go to, they have their hands full. Probate estates probably about 3 to 5 times as many as they used to be before COVID. So, but let's go to the next slide. So, okay, what happens once the probate estate has been opened? Well, there are some responsibilities that the executor has to do. One of the things when the probate estate is opened is the executor or administrator has to swear under oath that he or she will faithfully, fulfill his or her duties. If not, that could potentially be a felony if they, for example, stole the money. But there are a number of things that they need to do, but some of the major ones are listed below. So you have to pay the creditors. You have to manage the assets. So what do I mean by managing the assets? Well, let's say somebody has a lot of assets, stocks, bonds, et cetera, et cetera. Usually the first thing the executor does is they liquidate it and put it into a checking account. If everyone agrees that all the beneficiaries say, no, we'd like the accounts to stay as they are, that's fine. I would make them sign something in writing saying that they're all fine with that, because if the executor has everything and they happen to be in a lot of stocks or bonds, and the market happens to crash, guess who's going to be sued? It's usually the executor or the administrator. Sometimes a will might waive that, but one of the first estates that I did when I used to do litigation many years ago was the fact that when there was one estate, there was about $12 million diversified in about 5 stocks. And of course, all of the stocks went down to about half the price, and the executor was being sued for $6 or $7 million. Not the area you want to be in. So oftentimes you do want to liquidate the real estate as well. Of course, if one of the beneficiaries wants to buy a house, or if everyone agrees that they want to keep the house or have the house distributed to the beneficiaries at the end, that's completely fine too. But you should have something in writing. Don't just take it for granted. The executor has to pay the taxes, pay any other, creditors. If there are any debts owed to the estate, they also have to collect those debts. And then when everything is done, they're responsible for distributing the correct amount of assets to beneficiaries. Now, usually the executor or administrator can also choose to take a fee for his or her services. The fees have to be, though, usually reasonable. What does reasonable mean? It means usually if you're not a CPA, an attorney, or a financial advisor, chances are your fee can be $25 to $30 an hour. And whatever fee you wind up getting is going to be subject to ordinary income taxes. It's not like as a beneficiary where you get it and you don't have to pay taxes. Well, at least you don't have to pay income taxes, I should say, on the estate. But if you are the executor or administrator, you are collecting a fee that is taxable. Most people generally don't take it unless the other beneficiaries make their life very difficult, or the estate is very cumbersome, or perhaps they're just not receiving any assets from the estate. They're just being named as a friend or family member, but they're not really a beneficiary. So oftentimes people ask, well, what can you take? Usually that's what you can take as the executor or administrator. I've even had it where some of the judges have said, even to a CPA or an attorney, no, you can only get $25 or $30 an hour. I do not act as executor for anyone though. And then we get to closing a decedent's estate. So what do you need to close the estate? Well, there needs to be a final report. In the final report, essentially, the executor or administrator needs to state that they fulfilled their duties, that there were or were not, taxes that have been paid, that all the beneficiaries have received their assets, that, is any money basically being held back? Because sometimes what happens is the estate is ready to be closed, but maybe the house was sold and money is being held back because the house that was sold had to, there were some property taxes that are not due yet. We didn't know how many they would be, and the attorney is holding some money back. Or perhaps we know there'll be some income taxes. We've held back enough money to pay for those income taxes, but otherwise all the claims against the estate have been paid. So those are some of the things they have to swear off on, and this is under oath penalties of perjury. So if they're not sure they've done everything, they better be sure, because a felony means either jail time of a year or more, or $1,000 or more, just depending. So usually it's not a concern, but you do have to be very careful when you are going through a probate. There's also court approval to close the estate and eventually discharge the executor or administrator. Oftentimes these are received, although some courts it is very difficult to actually get that court order. And then once that occurs, once the estate is closed, usually the assets are distributed to the rightful beneficiaries. The beneficiaries may be the heirs, they might be the beneficiaries under a will, etc. But as I stated earlier, usually probate is not necessary if you do plan ahead. If you haven't planned ahead, if you haven't kept your forms up to date, then most likely you may wind up going through probate. Although, as we'll see next time, it is much better to go through probate than to try to draft the document on your own, because trying to undo things that have been done poorly is a lot more expensive and time consuming if there would be nothing whatsoever. So I'm going to move to our second topic today, and this is basically guardianship for disabled adults. Now, guardianship is the court process for appointing an individual known as the guardian to make decisions, which could either be healthcare or financial decisions, or both, on behalf of an adult. And a lot of people would assume, if they've ever given any thought to this, well, maybe if I become disabled, my spouse could make decisions for me. My husband or wife could make my decisions. Maybe my adult child could make decisions for me. Or maybe my child who's 18 or 19 and living at home and working or going to school, maybe I could make decisions for him or her, correct? Unfortunately, that is not the case for something that's going to be ongoing. If somebody is in a coma or otherwise unconscious, is incapable of making their decisions, healthcare, financial, or both, a guardian is going to need to be appointed. And unlike probate, where the process, as I said, is a minimum of 6 months, guardianship usually lasts from the time somebody becomes permanently disabled until their death. And that's with ongoing court calls at least once a year, also with attorney fees, usually yearly, and with accountings and annual reports, as we'll see in a moment. So what do we need to do to open an estate for a disabled adult? What if you know somebody who really can't make his or her decisions, has difficulty paying their bills, maybe can't take their medications, whatever it may be? Well, the first thing that you're going to need is a physician's report. It's a particular one. It's usually a form that's held on the Cook County website or DuPage or Lake or whatever county you live in. But there's a physician's report. The person who is allegedly disabled, the doctor has to fill out the report and state, can they make all of their healthcare decisions, some of their healthcare decisions, or none of them? And the same thing for financial. Can they make some of their financial decisions, all of their decisions, or none of them? Usually it's none of them. But the court does not like to take away somebody's ability to make decisions. Many years ago, it used to be you could have somebody very easily committed. If you didn't want to get a divorce, sometimes you could actually have your spouse committed. But because the courts really don't want to take away anyone's freedom to make decisions, that's why there is the guardianship process. And if it's Cook County, everything happens on the 18th floor. Probate for decedent's estate, guardianship for adults, and guardianship for minors is all on the 18th floor with one of the probate judges. So also guardianship is a much more, at least for an adult, it's a much more intrusive process. In addition to the physician's report, there has to be service by a Cook County sheriff. So what happens is generally somebody hires an attorney and provides the attorney with the physician's report. Once the estate is getting ready to be opened, one thing that has to be done, the person who's allegedly disabled has to be given service by the sheriff in the county where they sit. And basically the notice is going to say somebody is stating that they think that you can't make your healthcare and or financial decisions. You have the right to an attorney. You have the right to appear in court. And this is the court date on which this guardianship hearing is going to begin. Also, the alleged disabled person has to be interviewed by a court-appointed attorney. That attorney does not represent the person who's disabled. They don't represent the person who's trying to be the guardian. They represent the eyes and ears of the court. They're for short called the GAL, or guardian ad litem. And this person basically will ask questions and interview the allegedly disabled person to just get a perspective on how they think this person could, legally or not legally make their decisions. It doesn't matter if the person won't speak, is in a coma, the GAL still has to come out. Years ago, I had one client who unfortunately was a little hard of hearing. He was in a nursing home. The GAL went out and he said, I'm here because you want to, somebody's saying you need a guardian. And the guy said, who was allegedly disabled, said, thank you very much. I don't think I need a gardener. I already have somebody who does my landscaping. Now, the GAL, when he came to court, said perhaps the ward would benefit from having a hearing aid, but given all things in consideration, when he was in a nursing home in a suit with a briefcase asking this guy, he clearly wasn't a guardian. And the fact that the alleged disabled person wished the GAL Merry Christmas and it was in the middle of July, it was a clear indication that he probably couldn't make his decisions too well. There also is notice to the family. Well, there is a pecking order for who should be the guardian. If you're married, it's probably going to be your spouse, but if you're married and you have kids, they may be equal. If you have, 4 or 5 kids, they all may have equal pecking order. And usually they're going to need to agree to who the guardian should be. It could be more than one person, but I never recommend it. It always makes things a lot more difficult and expensive if there's more than one of them. The only reason where I would say that's not correct, I've had a number of people where, let's say, for example, there's a disabled person and the guardian is the parent, but the parent is getting much older oftentimes than one kid of the one or more of the children may join as co-guardians, just to make sure that if the parent dies or becomes disabled, there's somebody there in order to make decisions for the disabled person without there being an emergency. So, and they're also, much like before, there has to be a petition. That's usually one of the first things you have to ask the court to be appointed to make decisions. Keep in mind, if you want to do something like move the disabled person to a different state, if you want to sell their real estate or do something out of the norm, you're going to have to get court approval for everything. Now, this is very easy to avoid. Anyone who is not disabled from the time, from before when they were 18 could have avoided this by using powers of attorney and or a trust, as we'll see in the presentation next week. But also, I'd encourage people, if somebody really can't make their decisions, I would say try to go into court as quickly as possible. Nothing is gained by waiting. Oftentimes people say, well, I've been taking care of my son or my daughter or my parents for the last 5 years. I don't know why I need to be a guardian. Well, there very easily could be. If that person also has a lawsuit, let's say personal injury, medical malpractice, if you want to sue, you're going to have to either have a power of attorney in place, or you're going to have to open up a guardianship estate. A lot of times people will come to me and say, well, my mom or dad is disabled and I'd really like a power of attorney. And I say, no, you can't get a power of attorney after the person is disabled. You need to do that before the person is disabled so they can make their decision while they're competent. If they're incompetent, your only choice is to go into guardianship court. Now, there are a number of responsibilities for a guardian for a disabled adult. First one is managing their health care, managing their living arrangements, managing their finances. By managing their finances, it doesn't mean doing what the disabled person wants. It means doing what is best for them. So if they say, hey, I'm disabled, and they say, I'd really like, I want to drive a Ferrari. The guardian may say, no, you need a car. We might be able to get you a Honda or a Toyota, but you're probably not going to be getting a Ferrari. But you would have to get, court approval for these. And sometimes, somebody is dealing with millions of dollars. Sometimes somebody is trying to stretch out, $5,000 or $10,000 for as long as they can to take care of this individual. And for people that don't have a lot of money or are otherwise eligible for government programs, part of the responsibility is to apply. If the person was a veteran, if the person doesn't have a lot of money, do they need Social Security disability income, supplemental security income, etc. They also do have to provide annual accountings. They have to show, okay, this year we started with X amount of money. Here are all of the expenses, the dates. Here's all the money that came into the estate, and this is what we're left with at the end of the day. And you have to do that every year. You also have to have something called an annual report. It's basically a healthcare report. So you can say, hey, this person has gotten much better. You can say the person has gotten much worse, but for most people, it's usually a status quo. Usually when they're disabled, not a lot has generally changed. Some people, their health deteriorates very quickly. Unfortunately, when somebody needs a guardian, oftentimes their health does deteriorate much more rapidly than we would think. One of my first clients I had, I remember he was in great shape when I first met him. He was a very sharp guy, but over the years, he was clearly slipping. He couldn't pay his bills, and he was doing estate planning with me, but he could still make his decisions. So he had wills and trust and powers of attorney, but we made those effective immediately. So his family could make decisions, but, where he could recognize me and knew me very well at one point, towards the end, he didn't even recognize his own children. He thought his grandchildren, his granddaughter was his wife. So, I encourage people, don't really wait for these things. Estate planning is something people like to put off. And when somebody needs a probate estate or a guardianship estate, people often wait too, but sometimes there's an emergency and you can't get what you need done, or it's going to be a lot more expensive and somebody has to go in for basically an emergency hearing if the judge will grant it, to try to do something preliminary until all of the proper steps can be done. But that's never the situation you want to be in, because it's a lot more stressful for a disabled person, their family, and a lot more stressful for the attorney too. So, and then how do you close a guardianship estate for a disabled adult? Well, there are really only two ways you can close a disabled estate. 99.9% of them, it's usually a death certificate. Usually the person who was disabled has passed away. Now, there is that 0.1%. I've only had one estate like this. Most attorneys have never seen one. It's called restoration. If the person was disabled but has somehow regained their capacity, the guardianship can be terminated. This can happen if, let's say, somebody is in a coma and they wake up. I had one client who it wasn't the client, it was the guardian, it was his father, and he was schizophrenic. He was off his meds and he couldn't make his decisions. But fortunately, he went back on his medication and he was completely capable of making his own decisions. He was a very bright guy. I mean, there's nothing to say against that. He wound up doing computer programming. But he was able to be, restored. But the judge did tell me, hey, when he's restored, you need to do powers of attorney for him. He's got no choice, because I'm worried he's going to wind up here again, if he goes off his meds again. So that can happen, but very, very rarely does somebody ever get restored or come out of a coma or their condition. Usually the most common one is the one that I gave you, where somebody was off their medications and now they're on, or perhaps they had some kind of addiction and maybe they've gone through treatment and they've beat it. At the point when the estate is being closed, there has to be a final accounting that has to be approved by the court and perhaps other family members. The court has to approve the estate and discharge the guardian. The guardian also, much I should have pointed out before, the guardian is also going to need a bond, and there may be probate for decedent's estate if appropriate. So what can happen? I can give one good example for this. I had one lady a number of years ago, well, it was actually a husband and wife, and they were coming in to do wills and powers of attorney with me. And I asked them, when do you want to come sign your documents? Husband said, I think we'd like to come in about a month. And I said, well, you've already paid me and I've already got the forms ready. Why do you want to wait a month to come in? And the husband said, well, we've got a lot going on. And by the way, next week, my wife has some minor surgery. I said, minor surgery? He said, no, don't worry. It's just an outpatient procedure. I still try to encourage him to come in. He just said, thanks, we'll see you in a month. In a month, I did get a call from him. Unfortunately, it was not the call I wanted. He said, well, my wife was doing fine, but there were some complications. She had to go back to the hospital, and now she's in a coma. They're asking for her power of attorney for healthcare and property. You've already got them drawn up. Can't we use them? Well, of course not. She didn't sign them. They weren't witnessed. They weren't notarized. So even though everything was drawn up, because they were not signed, we had to go in court and get a guardian. Now, a lot of people will say, well, they're husband and wife. Well, they could have had joint accounts, sure, but you can't have a joint account for an IRA or a 401k. And guess where most people's money generally is? That's all she had. She had several hundreds of thousands of dollars in her IRA. And then later she passed away. Obviously, there was no will. She had, fortunately, listed beneficiaries on her IRA. Unfortunately, those beneficiaries were her parents who were long deceased. There was about $150,000 left in it. So even after guardianship, we had to go into probate, open up a probate estate where the husband was eventually able to get the money. Would have been a lot cheaper if they would have actually finished listening to me and signing their documents. So it's not enough to start your estate planning. You do have to finish it. And now guardianship for a minor. Unfortunately, guardianship for a minor, if you need this, this is not something that can easily be avoided unless you are giving money to a minor. Now, guardianship for a minor is the court process for appointing somebody known as the guardian to make healthcare or financial decisions, or both, for a minor. But why do you need guardianship for a minor? Well, there are three usually main reasons. One could be that the child's parents are deceased. They're a minor, they're under the age of 18, and the child, somebody's going to need to take care of them, provide them a place to live, food, clothing, shelter, education, etc. Could be personal injury. Well, if the child is personally injured, and I dealt with a number of these in the past as well, let's say the child is injured by a car. And you'd assume, well, it says, if you look at the law, it says the guardian has to appear. And you'd assume, well, I'm the parent, I'm their guardian, right? No, the guardian still has to be appointed by the court. So if you want to sue for a personal injury to a minor child, you are going to have to go into court. You're going to have to be appointed as the guardian for the minor in order to settle a personal injury suit where the child was injured. Also, the child could be a beneficiary of a decedent. If somebody's died and left the child as an outright beneficiary, or left them as the beneficiary of an IRA or a 401k or a bank account, somebody wants to use that money or receive that money, they may need to go into court and get a guardianship appointed. The last one is the only one that can always be avoided. If the person who's leaving their money had planned ahead appropriately, usually with a trust, that money could be held by somebody else until they're 18 or whatever age or ages the person thinks is appropriate. Also, much like before, there is a petition. Somebody has to ask the court to be appointed. Usually it's the child's parents, but not necessarily. Oftentimes it's one of their parents, not both, but it could be both of them. The family has to get notice, but the court also has to look at the suitability of the guardian. Especially, if it's personal injury, they may look to a degree, but when the parents are deceased and the child is actually going to be living with the person, the court is really going to look at that person. Even with a will or a trust, and usually what I oftentimes do is if there's a minor child, I'll ask the parent or parents, who would be your first, second, third choice, etc., to care for your child if you became disabled? Who will manage their health care? Where will they live? And who's going to manage their money? And they can choose whoever they'd like. The court will usually abide by them unless there are some issues. If the person that they've appointed is a felon, has been convicted, especially for some like violent crime, drugs, the court will oftentimes look for somebody else. The court also doesn't like it if the person is in another state or another country. It's not to say they won't do it, but if the person that you're selecting is out of the country, I always try to tell my clients, try to look for at least one person, a friend, a family member who happens to live here. So in case the court declines to allow that, and the court may decline, not because they're trying to be difficult, but the court wants to make sure that basically they have control of the situation for the minor. And if the minor moves out of the country, they have no more control to make sure that that minor is being protected. Now, much like before for a minor, and this is usually for when the parents are deceased, you have to manage their health care, manage their living arrangements, manage their finances, apply for government programs. You also have accounting to the court and annual reports. And the other thing that people may not tell you is, well, what happens when the kids become 18? Well, they receive all of the money. And this is the point where I could give you another good example. So I had one client who came to me, his son who was 19 died because of a car accident, and there was a personal injury settlement. The personal injury, because it was a settlement, the probate court actually did have to approve the settlement. And the heirs, basically, because the individual who died never drafted a will, were his parents and two of his minor siblings. And so with $1 million, so $250,000 going to his mother, $250,000 going to his father, $250,000 going to his brother, and $250,000 going to the sister. And of course, the parents said to me, hey, we really don't want our other two kids to have $250,000 when they became 18. And I had to tell them, nothing we can really do about that. You know, if your son would have done a will, this could have been avoided, but obviously he didn't have one. So, you know, try to teach your kids how to financially manage that money, but you have no choice. And it's a big pill for people to swallow, but oftentimes in, for example, personal injury cases or wrongful death cases, when the person has died, somebody may come to me and say, well, my mom or dad, you know, passed away, and we want to have a personal injury suit. And I say, great, I can, one of my colleagues does personal injury and I can help you with the wrongful death or some of the aspects of probate with wrongful death. But despite the fact that he hasn't spoken to his other child or children for 20 years, they're getting just as much money as you will. And sometimes people who are not planning because they have very small estates wind up with very large estates. And if you have will, it's going to go equally whether they were close to the person or not, if it was wrongful death. So I always encourage people, to consider at a minimum doing a will because sometimes they have strange circumstances. I've had clients who've been on Medicaid who have left estates with several millions of dollars because of a wrongful death or personal injury case. So. And then how do we close an estate for a minor? Well, there are a number of ways you can close an estate for a minor. The minor can turn 18, in which case it's usually the estate is then terminated and any of the money goes to the minor child, or if the child is, living with somebody, obviously they're responsible for themselves once they become 18. Now, if the person is disabled, let's say because of personal injury, maybe from birth or for whatever reason, then when that child turns 18, you actually do have to apply to the court again to become a guardian for a disabled adult. If the person has also died, you need a death certificate. And if that individual had $100,000 or more in his own name or any real estate in his own name, probate would be required. There's also final accounting. And then there needs to be court approval to close the estate and just discharge the guardian. Just because there's no money or the kids become 18, it may not be automatic. Oftentimes you have to get something from the court discharging the guardian. Otherwise, the guardian may still be liable, or I wouldn't say may, would still be liable. So that's probate and guardianship in a nutshell, as quickly as I could go through it with it. But if you see me next week, you can find out how almost all of this could be avoided. Well, thank you
Okay.
very much. I hope everyone has enjoyed the program. I'll look forward to seeing hopefully most of you at least next week for Wills, Trust, and Probate, so you can figure out how to avoid the fun process of probate and guardianship, or at least for most cases, I should say.
That sounds like a good idea. All right, so thank you, Jacob. We will see you next week, and I'll go ahead and end this. Thank you so much.